Welcome, everyone, to the Mental Health Parity and Addiction Equity Act Check Yourself Before You Wreck Yourself webinar. Thank you all so much for joining us. Our moderator for today's call is Carol Wood. She will be answering the questions you sent through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we are unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At this time, I'd like to introduce our speakers for today's webinar. Joining us today are Elizabeth Allen, Vice President and Counsel of Benefits Compliance and Plan Documentation Operations at NFP, and Sarah Burns, Vice President and Counsel of Benefits Compliance at NFP. We're very excited to have them speaking with us today. It is my pleasure to hand over the call to our speaker. Sarah, the floor is yours.
Thanks, Amber, and thanks everyone for joining us today. We had a bit of fun with the title there, but we do recognize that this is a difficult and a serious topic. So we're going to walk through what we know, what we don't know, what we hope to know, and offer some guidance on navigating MHPAEA compliance. There you'll see our smiling faces. So shows you how much we love compliance, and happy to talk about MHPAEA today. If we can move on to the agenda, and there's legal disclaimer, of course. This presentation is just for general guidance, educational purposes. It's not intended to constitute legal advice. If you have any questions about how MHPAEA applies to your plan, definitely bring those to your legal counsel. Also note that the content in here is only good as of today, October 19th. Certainly anything could happen tomorrow, so keep that in mind. So our agenda today, we'll start with a bit of a refresher on MHPAEA. On this, I want to note that we did a GetWise Wednesday last year in May 2021. So if you're looking for more detail on MHPAEA, definitely go check out that. But we will do a bit of a refresher today on the background of the law, and also what an NQTL, non-quantitative treatment limitation, even is. Then we'll move on to the newish comparative analysis requirement. We'll look at some recent DOL enforcement efforts, especially in light of the comparative analysis requirement. We'll review a selection of participant lawsuits and the lessons to be learned there. And then we'll look ahead on enforcement and legislation and review some compliance takeaways. So as we go along, feel free to send questions in the Q&A there. We have our team who will be answering as many questions as possible. And we'll keep a look at that. We'll keep an eye out for that as well. So Beth, I will throw it over to you to start with the background.
Thank you so much, Sarah, and welcome everybody to this call. For those of you who are used to coming to these calls, you might have noticed that I have not been on the last 3 of them because I was out on maternity leave with a little baby. So I am back though in full effect and coming to talk about MHPAEA on some of my first few days back, but it is a subject that I like, so we're going to jump into it. So MHPAEA. That stands for the Mental Health Parity, Addiction, and Equity Act. It came along as technically the last piece of legislation that we got on mental health parity, right? Like the mental health parity kind of journey started way back, really like in the Bush administration, where we saw the first pieces of legislation having to do with this idea that we want mental health coverage to be offered in parity with medical surgical coverage, okay? And so it's important to note that when we talk about mental health parity, it still does not actually require group health plans to provide mental health benefits or substance use disorder benefits. And so the law doesn't say that you have to cover it. It just says that if you do, then it has to be offered in parity with the medical surgical coverage that you provide. Okay. Interestingly, we know that the Biden administration is open to potentially putting in, let's say, the next reconciliation bill, the idea that mental health would have to be covered, but we don't have that yet. And then also for our small group plans that are going to be subject to the essential health benefits rules, generally there are going to be some requirements that mental health coverage is provided, okay? And so that is something that we do see where some plans don't necessarily have the choice not to offer it, but when we think about kind of those large self-funded plans, they still can choose not to offer coverage for mental health benefits or substance use disorder benefits, okay? And so really, when it comes to what MHPAEA is going to require, it's going to say that those plans that offer mental health coverage or substance use disorder coverage have to do it in parity with the medical surgical coverage as it pertains to lifetime and dollar limits, financial requirements, and treatment limitations. Now, with that aggregate lifetime and dollar limits, you all know that as of the ACA, a lot of those have kind of gone away, right? But you could still potentially have certain types of coverage or benefits that are subject to a limit. And if you have those on the mental health side, you're going to also want to see those on the medical surgical side if that happens, okay? As it pertains to financial requirements, that's where we're talking about your co-pays or your co-insurance or your deductibles and those kind of number-based requirements that we see on a plan that are going to need to be in parity, right? And so when we're talking about, financial requirements, it would be a red flag where we see, let's say, a copay on the medical surgical side that is less than the copay that is on the mental health coverage. There's also going to be the requirement for parity as it pertains to non-quantitative treatment limitations or treatment limitations. And we're going to go into more detail about that because a large part of the conversation today has to do with the CAA's requirement or the Consolidated Appropriations Act requirement for plans to provide a report that outlines the non-quantitative treatment limitations. Now, mind you, prior to MHPAEA, plans kind of, like I said, they weren't forced to cover mental health. They're still not forced to cover mental health. But if they did cover it, we saw a lot of limitations on what was covered under the plan. And usually what we would see is, limits on the number of visits that you could have for mental health. And that absolutely added to kind of the stigma that we saw as it pertains to mental health. So who must comply with MHPAEA? Really, this is going to be pretty much the majority of group health plans that have to comply, and insurers. If they offer that medical surgical coverage as well as mental health coverage, then they're going to have to comply for the most part, right? That's going to apply to both fully insured plans and self-insured plans. And we don't see an exemption for, let's say, church plans like we would with ERISA, okay? However, there is a small employer exemption, right? So employers with 50 or fewer employees would not have to necessarily comply with mental health parity, but interestingly, they often do if they have a fully insured plan, right? Because the insurer is also having to comply. So they are going to indirectly be subject to MHPAEA because of the fact that they're offering a fully insured plan, really. So it's gonna be that small group, let's say self-insured plan, that is not going to have to comply. And when we're counting up to the number on that 50 or fewer, control group rules are going to apply. And so for a lot of benefits reasons, we point to control group rules and the common ownership rules that we get from the IRC. And we're going to say, okay, if you have those companies that are related, then they're going to be counted together for purposes of that 50 employee threshold. And then there's also an exception for self-insured non-federal governmental plans, and they can opt out of MHPAEA. So this is going to be your state and local governments that can potentially apply to the government to kind of opt out of complying with MHPAEA, but we always point out that there's actually like a process for that. So it can't just be that we opt out. They have to actually take steps to do that with the government. Now, when it comes to enforcement of MHPAEA, there's joint jurisdiction on this, right? And so you'll see the Department of Labor involved, who I think we're all used to kind of as it pertains to DOL audits of plans. The Department of Health and Human Services also shares jurisdiction over MHPAEA issues, as does the Department of the Treasury. And so a lot of the guidance that we get from MHPAEA and mental health parity, you will see come from all three of those groups because they do share jurisdiction. Now, I will say that I think the chunk of enforcement as it pertains to group health plans has come from the DOL, but keep in mind that you might see HHS get involved and the Treasury as well. And when we start to talk about enforcement of MHPAEA issues, what that is generally going to result in is re-adjudication of claims, okay? So for example, if the DOL comes out and realizes that the plan had a, let's say, copay that was not in parity on the mental health side, then they're going to go back and say, well, all those people who should have paid a lower copay plan, you need to pay them back that money. Okay, and so that's generally going to be their solve for issues as it pertains to MHPAEA. And as you can imagine, that can be very costly for plans and a hard situation. I'll also point out that a lot of states have mental health parity laws that are going to apply to fully insured policies that are going to be written in their state. Those state laws would not apply to self-funded plans because of ERISA preemption, but states can say, okay, if you write your policy out of our state, then you have to comply with our mental health parity rules, if you will. Now, what does parity mean? And this is kind of interesting because kind of how you look at this is kind of a really convoluted way of like determining certain things. And there are certain tests that apply. And as Sarah mentioned in the May 2021 presentation, we went into more detail on, I think, the rules of how you kind of figure this out. And so if you want to kind of learn about the tests that apply to, let's say, the cost sharing limitations on a plan and things like that, then that's a good webinar to go back and view. But ultimately, you see kind of this balancing act because it should be kind of the same to where those limitations that are imposed on mental health and substance use disorder are no more restrictive than the limitations that are applied to benefits in the same classification on the medical surgical side, okay? And there are 6 classifications, you know, and most of you who have dealt with MHPAEA kind of understand it's like, okay, in network, in office, in network, out of office, there's a number of those type of classifications. And in each of those, the plan has to be in parity on the mental health side. Now you'll see here on both sides that they have to be in parity on cost sharing, on the financial requirements, which is this middle kind of set of boxes, and then the non-quantitative treatment limitations as well. All right, let's see. Can self-insured local government plans opt out as in public schools? And yes, and I mentioned that, you know, so if you are a self-insured local government plan, and that can be kind of, like I said, the state or local government, that could also potentially be, let's say, other entities that roll up to the state, such as public school districts, or let's say maybe fire departments. Honestly, that is going to be an analysis that a local government would need to do with their council just to make sure that they fit under that. But usually there's no question unless we have entities that are like, let's say, quasi-governmental, if that makes sense. So look at me addressing a question on the fly on my first day back on GWW. But now let's get into understanding non-quantitative treatment limitations, okay? So on non-quantitative treatment limitations, the rule there is that the NQTL must be designed and written comparably to and applied no more stringently than the non-quantitative treatment limitations that are imposed on the medical and surgical side. So with this, we're looking at the processes and the strategies and the evidentiary standards that are reviewed or looked at when it comes to determining that the plan is going to apply that NQTL, okay? Now, mind you, this is not easy stuff, right? And frankly, this is not stuff that employers really understand, because chances are if an employer has a plan, they did not make the decision to put this NQTL in the plan, right? That was done by the insurer, that was done by the TPA for a self-insured plan. And the employer just kind of got a product or a plan that they offer that has these in place. But that's kind of what makes it very difficult to recognize NQTLs and to understand what MHPAEA requires as it pertains to them, okay? And so luckily, kind of the government has gone through and identified a number of NQTLs that you can notice and understand what they're talking about when they refer to them, okay? So you see this list that we have, you know, things like medical management standards. So for example, saying that someone who is, you know, seeing a doctor for mental health has to go through certain medical management hoops, or, you know, talk to a nurse or someone before receiving certain treatment. That is generally going to be considered an NQTL. Likewise, if there's a formulary design for prescription drugs that puts certain drugs into certain tiers, and for example, all the mental health drugs are in a higher tier or a higher cost tier, that might be a problem as well. Likewise, the rest of the things on these lists are going to be NQTLs that are examples of NQTLs, but they're not an exhaustive list, okay? So there could be other things in the plan that are considered NQTLs that the plan would have to look out for and know that they're in parity. So the comparative analysis, what's required? Basically what we got here was a bill from the government when they came out with reconciliation in 2020, where they basically came out and required that health plans provide a report that documents the NQTLs that apply in their plan, okay? And interestingly, I'd like to kind of just stop and say how we got to this point, right? As someone who was at the Department of Labor earlier on in mental health parity, I could say that when the first or the original rules came out, and this is even pre-MHPAEA, going just back to the MHP, that basically the DOL and the insurers kind of started to engage in this back and forth that has taken over a decade at this point, okay? So they came out with the mental health parity rules. They kind of said, look, you need to make sure that your stuff is in parity. And then the DOL would come and check and see, okay, are things in parity? And they looked at financial requirements first, because those are the easiest things to look at, okay? And so they would go out to the insurer, they'd say, look, this is not in parity. What the insurers first said was, well, it is, we had to have this difference in because of medical management, right? And then the government would say, well, how, or show us the proof. And the insurers would like data dump and just put a bunch of documents on them, none of which prove that, that was actually in parity, but it did take quite a bit of time up, right? So we went through that with financial requirements. And then the DOL kind of, once they were able to get insurers to fix financial requirements, moved on to NQTLs, and kind of similarly to financial requirements, had a very hard time getting insurers to respond, and to kind of point out the NQTLs and point out the justification for having them. And so that's where the CAA came in, where it came in and said, okay, look, you need to have a document that shows basically that you're in compliance with the NQTL requirement, or the requirement that those be in parity. And you need to be able to show us how they are in parity, okay? And so as of February 10th, 2021, plans were supposed to provide a comparative analysis to the government if they requested, or a plan participant. Now, interestingly, the industry was pretty much up in arms, because the CAA came out, let's say in December of 2020, and this report was due by February 10th of 2021. And everyone was like, that's so fast. How dare the DOL come out and say that we need to put that together? But the DOL's kind of reasoning, and Sarah's going to go into their enforcement of this, but their reasoning was the idea that if you had an NQTL in your plan at all, then you should have already known it was in parity, right? And so they did not feel like they were asking for something that these plans shouldn't have already had, frankly, because if there were NQTLs in the plan, then they needed to be able to justify them already. And so that's where we kind of see this comparative analysis requirement be born. And then who's responsible to comply? And I think this has been one of the harder aspects of having to deal with the CAA required report, is that with fully insured plans, the employer, plan sponsor, and the insurance carrier carry the responsibility, but the insurance carrier kind of has to provide it, right? And so we saw a lot of insurance carriers kind of struggle, but they eventually came up with some version of it. On the self-insured plan side, it's really the employer plan sponsor that is responsible. But as I mentioned, that employer plan sponsor probably didn't put those NQTLs in their plan. So they're not familiar with what the NQTLs are. Better yet, whether or not they are in parity with the medical surgical NQTLs. And so for self-insured plans, they can utilize the TPA if the TPA is willing to take on that responsibility. And I think it was hard because we saw a lot of TPAs who kind of at first threw their hands up. I think more of them are coming around, but this was definitely kind of a struggle area for self-insured plans. Now, as I kind of mentioned, how does an employer plan sponsor comply? On the fully insured side, that insurer was responsible to create one, right? So employers would want to basically make sure that the carrier actually completed an analysis and get a copy, right? Because I think that there were a lot of insurers who came out and said, okay, we have it, come ask us. And some of them even said, come ask us if the government asks you for it. But the reality is that at any moment, a participant can come in and ask an employer for this report, and they should have it, right? And so knowing that the carrier completed it is really not necessarily enough. Like, you want to make sure you have a copy on hand so that you're not having to, make a participant wait, or make the government wait if they come and ask you for it. Self-insured plans have to work with those TPAs to, to be able to provide this report. And so again, I know that has been a sticking point and a little bit difficult for our self-insured plans, but that's how they're going to have to go about complying. And then what are the deadlines for compliance? I mentioned that this was due in February of 2021, right? And like I said, the department has been adamant about that. Sarah's going to talk about enforcement of this requirement in a bit, but they have been adamant that you need to have one of these, and you need to to basically provide it when it's asked for. If the DOL does ask for it and review it, and they come back and indicate that there's a parity violation, or that the excuse me, or that the report is not sufficient, then the plan has 45 days to provide additional information or analysis to show, that they are going to correct the violation, or that they feel that their plan is in parity. If the DOL makes a determination that the plan is out of compliance, then basically the plan is going to have to let all of their employees or their participants know that they're not compliant, and they have to do that within 7 days. And we've seen this have to happen with some plans so far that might have been reviewed. And then obviously the DOL is reporting its findings to applicable state and federal officials, so this is one of those things where, you really should have one of these already. But goodness, if you do get asked for it, then you definitely want to move quickly to provide it, so that you don't start running afoul of some of the compliance deadlines that are in place. So when it comes to this analysis, we do want the analysis to be detailed and thorough. It shouldn't just be, like I said, a data dump. So it really needs to be a thorough analysis of the NQTLs that are in the plan and how they're in parity, and so obviously on the don't side, being vague or providing this cursory or general compliance statement. So, oh yeah, this is the NQTL, we're in parity, is really not enough, but that is what we saw from a lot of different reports that first came out. Obviously, the guidance provides very specific content requirements for each of the NQTLs that are in the plan. So you want to at least make sure that each of those content requirements are provided in the report, because if not, then it's kind of easy for the DOL to tell that it's not actually in compliance. The data, processes, and strategies utilized is what this report is really getting at. So you want that to be included in the report. And then there needs to be evidence and a well-reasoned conclusion. And like I said, not just kind of this idea that we are compliant, right? As far as the don'ts, it's kind of the opposite of everything else I just mentioned, right? But we did see, again, this idea of like just a data dump and giving documents to review versus a detailed report, not putting in the required contents, not providing, let's say, an explanation of, how, let's say, an NQTL that's different on the mental health side is actually in parity. And then also don't assume that the carrier or TPA is compliant. Like I kind of mentioned, this has been a longstanding kind of journey between the DOL and insurers. And just because insurers are out there or are very large or might even be the largest in the country does not mean that they have been in compliance with MHPAEA or even this requirement to provide this analysis. And so you can't just trust that, that particular carrier or TPA is doing what they're supposed to do. So with that, Sarah, I'm going to turn it over to you to talk about DOL enforcement activity.
Great. And thanks, Beth. That background was really helpful, especially with your perspective being in the DOL. Interestingly, around the same time, I think that the courts were also grappling with how to handle these NQTLs. It's different in each plan. So it's interesting to hear that the DOL was also grappling with that. And that was the push towards the comparative analysis. So on DOL enforcement, it's hot right now. The DOL has said again and again, I don't think they can say it enough, that MHPAEA is an enforcement priority. The CAA directs the DOL to investigate at least 20 plans each year. But back in 2021, which was a partial year because the requirement became in effect in February, they went well above that, 86 plans. So, and many of those were already being investigated, but I think we can reasonably expect for the DOL to go above the 20 plan mandate again. And remember, as Beth just mentioned, if a plan is found to be non-compliant by the DOL at the end of the investigation, they have to notify all the enrollees within 7 days. The DOL is also going to publicly identify those non-compliant plans. So that's this sort of naming and shaming. What it's going to do is invite lawsuits from participants who were denied benefits. You're going to have a target on your back. So moving on to the January 2022 report to Congress, this reporting isn't new. MHPAEA requires it every 2 years. But given 2021's introduction of the comparative analysis, the 2022 report was particularly noteworthy, and it focused on their collection of those analysis. analyses, I guess. They were all ongoing investigations. There weren't any final determinations yet, and we still haven't heard of any final determinations. But the too long didn't read here is just that everyone's failing. no one's getting it right, at least as of January. They either didn't provide enough information, or they could tell from the information that was provided that the plan had problematic NQTLs. I think it was interesting that the DOL described the process of gathering the information as difficult, as time consuming, because it is, right? It requires expertise. It requires a lot of different documents and plan and operational information, but that shouldn't be interpreted as an excuse for not complying, not at all. Some common problems that were called out, again, this is just that they didn't have it ready to go. They, some plans just threw a stack of papers at the DOL without demonstrating that all the NQTLs actually were in parity. It's that multi-step process that Beth talked about. So a broad statement, just like we apply medical necessity criteria, we apply utilization review to all benefits, that's not going to cut it in the DOL's eyes. Can you go to the next slide? Thanks, Beth. So there are also a few NQTLs called out in the report that the DOL was commonly seen. And these aren't new. These also were kind of called out in previous DOL guidance, but it's worth reviewing them. Limiting and excluding applied behavioral analysis therapy, or ABA therapy, or some other autism treatment. The report discussed an investigation of a TPA that was providing claims administration to self-insured group health plans. And the TPA was providing a design that defaulted to an ABA treatment exclusion. So the employer actually had to opt in for ABA coverage. And many employers didn't realize the significance of this. So it resulted in a lot of self-insured plans with an ABA exclusion. And generally the DOL or court would consider an ABA exclusion to violate MHPAEA where there isn't a comparable medical surgical exclusion. And I think on that note, we can talk about these other exclusions, because I think they're going to be inherently suspect if you just have an exclusion on the mental health side. It's not that the plan can exclude, it's just that any exclusion needs to be based on a non-discriminatory reason. So when you have a proven standard of care treatment like ABA, you have trouble justifying that exclusion. What is the reason? Some other exclusions called out in the report covering methadone for pain management, but not for opioid disorder, covering nutritional counseling for diabetes, but not for anorexia. Again, the plan needs to answer why is there a coverage disparity? What is it based on? And then there are a few NQTLs that they called out in particular focus. Those have little asterisks at the end. Prior authorizations, so that's requiring approval before treatment begins. Continuing care reviews, that's a requirement in the middle of a treatment plan to get continued approval. Again, these aren't banned, it's just that the plan has to apply them equally or have a good reason to require why they're only applying them on the mental health side. It's significant, these sorts of NQTLs, they make it more difficult to access treatment. It's just additional coverage hurdles, so it really is a true treatment limitation.
Can I bring up something here, Sarah, if you don't mind?
Sure, please.
So interestingly, those of you who have been in this field for a long time, the DOL is not generally in the practice of coming out and saying, within the law, these are the areas we are focusing on, right? They're looking at the entire law, right? So like the fact that with MHPAEA, they came out and told us very specific ones they're focusing on. The reason is because those are kind of the low-hanging fruit of MHPAEA violations that pretty much all investigators are going to be trained and be able to spot. Right? It doesn't mean that you can't have other NQTLs that are going to get also dinged, but the fact that they came out and said, hey, this is what we're specifically looking at, or this is what's trending, means that you want to at least check your plan to make sure these are taken care of, right?
Yeah, no, that's a great point. I think at least all of these listed as far as NQTLs go are relatively easy to spot, like the limitation exclusions, that's going to be in the plan document, pre-authorization might be in there too. The network provider emission standards, you can probably get your hands on those easily. Yeah, so that's a great point. I didn't actually realize that it's something that might just be easier to apply the comparative analysis to, but it doesn't mean that you get away from not not having to apply the comparative analysis to any other NQTLs. It's just that these are in their focus.
Right.
All right, next slide. So the report also had a series of recommendations to Congress. First, they're going to continue enforcement on MHPAEA, strong enforcement. They said that they would that there would be additional rulemaking. We haven't seen that yet. We are keeping an eye out for it. We in the compliance world are hoping for a lot more guidance in the comparative analysis, like a passing sample would be nice. And then there was this sort of wish list to Congress for additional authority, both for penalties, so MHPAEA penalties. Right now, there aren't MHPAEA penalties. And then also authority to pursue violations directly against TPAs. Right now, they have to sort of do a dance because the DOL only has authority over the plans. So they would need to first establish the TPA as a plan fiduciary, establish that connection between the TPA and the plan. So it really impedes global corrections. It's an inefficient enforcement process. So they're trying to get different authority on that. Let's see. Allow participants to sue under MHPAEA. Right now, they have to sue as a challenge to a denied claim under ERISA. So it's sort of like the MHPAEA claim has to hitch a ride on an ERISA claim, and it just complicates things. It makes it a lot more difficult to litigate. They are also hoping to expand access to telehealth. I think the value of telehealth therapy was really recognized in the pandemic. We were all at homes and struggling and needing some mental health care, and expanding that telehealth access is going to hopefully address some of these network issues, which again, that's an NQTL. And then amend MHPAEA. So for some clearer rules on what is a mental health benefit that is subject to MHPAEA, hopefully make compliance easier, some statutory clarity there. All right, next slide. So just one last thing on DOL enforcement. This is a bit different. So this is, let's see, this is Walsh versus United Behavioral Health. It was the New York Attorney General and the DOL. That's why it's Walsh. That's Secretary Marty Walsh brought a lawsuit to enforce MHPAEA following an investigation of UBH's claims practices. It went back years. The alleged violations were that UBH was arbitrarily flagging claims for review on the mental health side only. So what they were doing is on outpatient therapy, they were pulling the treatment for review after 21 sessions in a 6-month period. So that's fewer than once a week. And it was significant because the more frequently you have a claim reviewed, the more frequently they're going to be denied. So it would lead to abruptly ending treatment. If a member can't pay hundreds or thousands of dollars to continue that treatment, it had a real negative effect. The other parity problem that was alleged there was discounting out-of-network payments to mental health providers. They would apply across the board discount 25% for PhDs and 35% for master's level therapists. They were not doing that on the medical surgical side. And then along with the first two, they weren't disclosing that these limitations actually existed. So members didn't know about it. So there was a settlement, money to impacted members, ERISA penalties, and then importantly, UBH agreed to change their practices in this respect. So if we move on to lawsuits, do we have any questions or not quite yet? So these lawsuits, just to kind of set the stage a little bit, they're filed weekly or daily across the country. Most settle, but we selected a few opinions to review. We think they're kind of helpful, illustrative, cautionary tales. They're going to be brought by plan participants, covered employees, dependents who have had care denied. It's going to be brought against the plan and fiduciaries to the plan, those your insurer, your TPA, or your self-funded employer. Case law is developing in this area, but it's very plan, very treatment, very member specific. Still, I think there are good lessons to be learned. So we can go on to the next slide. So MS versus Premera Blue Cross. Premera here is the TPA and Blue Cross is the self-funded employer. This involved a residential treatment claim. Residential treatment is a common MHPAEA vehicle, so I think it's good to just pause and discuss what it is. It's a step below inpatient, but it's more intense than living at home and receiving treatment in a day program. So it's often out of network just because there aren't many contracted residential treatment providers. And it's very expensive. Treatment can go for months. I've seen it up to over a year, and it can cost $1,000 or more per day. Residential treatment is absolutely endorsed as a standard of care in the medical community for someone who is unable to live safely at home and receive treatment, but they're often denied. I would say less so, but in the beginning of MHPAEA, we would see them denied quite a bit. So here, in this case, the claim was that the medical necessity guidelines, the coverage guidelines, were more difficult to meet on the mental health side for the residential treatment as compared to the medical surgical side. Specifically, there is a second set of criteria applied in the mental health side. So the court found that applying that second set of criteria was indeed a impermissible NQTL. They just couldn't justify it. But really why we chose this case, and let's see, Beth, can you just click the slide one more time? Thanks, there's our lesson. So really why we chose this case is that the court also assessed over $123,000 in penalties. The penalties weren't under MHPAEA because there aren't penalties yet under MHPAEA. They're under ERISA. So plans shouldn't forget that these document disclosure requirements apply. Not new, again, under ERISA, so they've been around for decades. But what it means is that a plan has 30 days to respond to a participant's request for information, and the response has to be tailored to that request. So here the family asked for the criteria that was applied, and they asked for the administrative services agreement, and the plan delayed 2.5 years on providing the criteria and never provided the ASA. The penalty is now $110 a day. So as a plan, you need to make sure that there's a process in place to be responsive to these ERISA document disclosures, have them ready to go fully and timely. So our next case here, Jonathan Z, this involved a wilderness therapy exclusion. So wilderness therapy is like residential treatment. It's another common MHPAEA lawsuit vehicle, I think, because it's often excluded, really because it's often misunderstood, and I'll get into that, but it's also expensive treatment. So wilderness therapy or ranch program, it doesn't automatically mean that there's no clinical treatment provided. And again, like residential treatment, it can be endorsed as a standard of care for certain adolescents, certain young adults. I think that because of the patient population, the marketing of the program, the public marketing of the program kind of muddles the claims review process, because there's this effort to describe the program in a way that gets like a young adult to buy into the treatment. So the program name may suggest that there's this recreational part, that it's all recreational, but that's not always so. So what I mean to say is that these blanket exclusions are problematic, and that we get to actually look into what services are being provided. And that was the case in Jonathan Z. So the court found that denying coverage of the therapy sessions, medication management, access to psychiatric treatment, just because the treatment occurs outdoors, where there was no outdoor exclusion on the medical surgical side, that violated MHPAEA. Interestingly here, and very helpful, the court compared to another case where the wilderness exclusion applied on both sides. So on the medical surgical side, it applied to weight management or diabetes camps. And in that case, the exclusion passed. So the lesson here is just to be careful of these exclusions. Yes, it's a red flag if it's only applied on the mental health side. Take a look at the design there. Next slide, Beth. So NR v. Raytheon, this is the last case we're going to discuss. This involved a denial of speech therapy for autism based on the plan's non-restorative services exclusion. So for this child, they needed speech therapy to gain speech, not restore lost speech. The lower court, the district court, looked at the plan language, just the plan language, and saw that the exclusion applied on both sides, so found no MHPAEA problem. The defendant said that on the medical surgical side, they would apply the non-restorative services exclusion to someone with a cleft palate or deafness. So the plaintiffs appealed, and then the First Circuit said that looking at the plan terms as written is not the end of the story. You also need to look at how it's applied, and that's that in operation component that we've been talking about. So the lesson here, Beth, thank you, Beth. The lesson here is looking for red flags is really a good place to start, but you need to analyze further on how the claims are approved, how the claims are denied. And NR is just a really good example of this. On the face of the plan, it seemed to apply equally, but then if you look at the claims process, there's really a different story there. So, okay, how do you know, how do you know what's going on in the claims process, right? You, as a self-funding employer, only have the plan. Pay attention to participant complaints. I think that these are very useful clues that there are problems. And then secondly, that the denials are going to lead to lawsuits, because to have an ERISA lawsuit, you need to have a denial, or they're going to lead to DOL complaints, and DOL complaints lead to DOL investigations. So I think it's, again, very important to pay attention to these complaints. All right, so what's next? Looking ahead. We don't have a crystal ball, but we do know that DOL audits into MHPAEA are definitely going to continue. You need to have the comparative analysis completed. We're all hoping for more guidance from the DOL, like if they could introduce some objective standard, like listing the NQTLs, or have, comparable medical surgical categories to make that easier. Right now, it's very plan specific. The courts, it's going to change based on a given fact pattern. And then, like I said before, provide a model comparative analysis, exactly what that looks like, what information is needed to justify an NQTL. Let's see. Looking at new legislation, we talked about some of the amendments that the DOL is asking for. There's also this bill that the House passed September 29th called the Mental Health Matters Act. And it was largely focused on expanding access to services for kids or young adults through school-based funding. But it also included a significant amount of money for MHPAEA enforcement and increased enforcement authority, specifically fines, penalties for MHPAEA violations. But one really big deal here, and I think maybe it didn't get as much play in the press, which I was surprised about, is that it would change the standard of review for ERISA claims, all health claims. And this is kind of a complicated concept, so I'm going to do my best to break it down. But right now, most group health plans have clauses where the plan reserves discretion to decide the claim. So when a claim is denied, it goes to the appeals process, it ends up in court, and it's reviewed by a court. The court has to defer to the group health plan. Absent, some sort of procedural or serious error, that denial is going to be upheld, even if the court disagrees with the decision. So banning these discretionary clauses, changing the standard of review, would mean that courts actually get to stand in the shoes of the plan and decide claims anew, take new evidence. It would fundamentally change ERISA litigation, make it much easier for plaintiffs to win on denied claims. So I could see that being cut from this bill. But certainly we will keep an eye on this and report on any developments for you. All right, so compliance considerations and top takeaways. So we've really looked at all the trees here, and now we're going to step back and look at the forest. Like I said, MHPAEA is going to continue to be an enforcement priority, at least through this administration. Why? Because the DOL has said so, and because new guidance typically equals increased enforcement. So we said, many times in this hour, plans need to have the comparative analysis ready to go, but a self-funded plan can't fix those problems alone. They need to reach out to the TPAs. Fully insured plans need to make sure the carriers are on top of this as well. A good place to start is reviewing the plan for red flags, and we have a guide to help with that. And also, plans should consider engaging a vendor to actually complete the comparative analysis. And I'm going to say it one more time. just pay attention to those participant complaints. It really often indicates a larger MHPAEA problem. Beth, anything to add there?
Yeah, so a couple things here. First of all, I like to kind of bring in the DOL perspective of this. The reality, I think, as it pertains to self-funded plans is this is a really tough place to be or position to be in if the TPA is not engaging the way you would like them to on this subject. What the DOL is looking for is if you have a self-funded TPA who just refuses to assist with this, then they're going to want you to pressure them, right? And so one of the things that I think a lot of kind of practitioners kind of came out and said was like, look, if you're at least able to identify your NQCLs, and your insurer is not able to, or your TPA is not able to provide you with any analysis as to why they're in parity, then you might want to consider taking them out, right? Or asking the insurer to take them out. Now, I've known a couple of clients to do that, and the insurer kind of tries to push back. And it's like, well, wait a minute, you can't tell me that you can't provide me with an analysis as to why it's in parity, but then we can't take them out in design. And the DOL really is going to want that employer to reconsider the relationship with that TPA. And that's very extreme, right? Because obviously there's a lot more that goes into the TPA that you chose than MHPAEA and compliance with that. But the DOL is really looking for employers to kind of pressure these insurers into acting right, frankly, in addition to the efforts that the DOL and the federal government is making, okay? The other thing I'll point out here, Sarah talked a little bit about potential legislation, and I will point out that there is pretty much bipartisan support as it pertains to MHPAEA and kind of moving the needle on making sure that parity actually happens. There are some disagreements as to kind of how that would be done best, but it's very clear that people on both sides of the aisle are very interested in making sure that mental health parity is actually something that happens, right? So I don't think this is something that we're going to see go away at all. So as she mentioned, it's not new, but we're going to continue to see this as an enforcement priority, in addition to seeing additional legislative kind of things coming out to make this happen. And so I don't think this is going to be the end of this situation by a long shot. And I think employers are going to do well to at least educate themselves on the aspects of this and figure out the conversations that they need to have with their TPA. I think there's some static on my line. Sorry about that, guys.
Yeah, but thank you, Beth, for breaking that down. And if we can just go on to the next slide, we can talk about what NFP can do for you all. We can't complete the comparative analysis, but we do have a guide that breaks it down and has a few tools there to help you take the first steps. First, there's a red flag list. I think we call it a suspect and QTL inventory, but it's a red flag list for you to take a look at your SPD before you engage the TPA and see if there's any red flags there. Also a template to work with your TPA and a guide to choosing a comparative analysis vendor. There are some out there, so we have some helpful tips with making that choice. And then the DOL has resources. The self-compliance tool, I think, is helpful. It is a bit technical, but the DOL has said, look, if you rely on this, then you're in a good place for completing the comparative analysis. Like I said, I hope by the end of this year, we have a couple months, I guess, or into next year, we actually get a comparative analysis sample. But until then, the DOL self-compliance tool is a good one to use.
If I can chime in about these tools, one of the reasons the DOL made these tools is, again, that issue, and hopefully my audio is a little better. I think my little USB was not plugged all the way in, so sorry about that. But one of the things that the DOL noticed as it pertains to enforcement of this is that, again, that employer is really stuck in between a rock and a hard place if they have a TPA that is not assisting, or even a fully insured insurer that's not assisting with MHPAEA. And so what the DOL is going to want to see is that the employer engages in some type of action to at least show that they're trying to be in compliance with MHPAEA, right? And so if you are one of those self-funded clients who has a TPA that's not working with you, then you want to at least try and go through these tools that the DOL provided. Because if an investigator reaches out to you, and let's say that you don't have the CAA, we want you to get it, right? And we want you to keep working with the insurer to get it. But if you at least have gone through the warning signs and things like that, then that is at least some goodwill on your part that you actually are not interested in just not being compliant, that you've actually tried to do exactly what you can do, and the rest is really up to the CPA.
Absolutely. Yeah, I would agree with that. Just to document whatever steps you're taking, whatever, engagement efforts you're trying to make with your TPA. Because I think an imperfect comparative analysis is better than waiting, because if you wait until the DOL comes knocking on your door, you do not have time. Getting these things together, it takes months, if not years, to get all the information. So again, I think an imperfect comparative analysis is better than waiting and better than having none at all.
Let's look and see if we have any questions. Sorry about the static on my part. I think I have a headset that's kind of going out on me.
It's better now, Beth.
Yeah, I took out the headset. So Carol, do you see anything that we want to address?
I do, and I think it was a question that you were looking at as well. It's a bit specific, but it involves, how would an employer or TPA go about understanding and documenting provider network credentialing disparities? And I don't know if that's a question where we would assume the TPA would have that information, but I wanted to get your thoughts on that.
Yeah, I definitely think that the employer is not going to have a lot of information on that. When we talk about provider network credentialing disparities, that's literally kind of the steps that, let's say, a provider has to take to be able to be considered in network versus out of network on a particular network. And so that's not something that the employer is doing. The TPA is selecting a network, right? And so they would probably have to look into whether or not there are any disparities there. I can't say that the employer will be able to do that at all.
Yes, and this ties to a question that was asked earlier. When you're not getting cooperation from the TPA, and I know, Sarah, your white paper addresses it, you really do need the cooperation, even if they're not directly providing the CAA analysis for you. You're going to need their cooperation to provide the data, because they're really in possession of most of it, and were involved with the design.
Yeah, absolutely. It really, you need the TPA's cooperation on two parts: the design, let's talk about an exclusion, why exclusion was put into a plan, like what were the standards that they relied on, why is it in there? But then also in operation, that goes to the claims administration process. And no, a self-funding employer is not going to have that detailed information. So yeah, absolutely need the cooperation on both of those parts.
I see that we did get a question about just vendors that might be available. And Sarah did do a great job of just vetting out a few vendors, and you can reach out to your advisor to potentially find out if any of those vendors might be a possibility or a way that you can go, but we have to kind of give the disclaimer that, we cannot really speak to kind of, the total compliance of any vendor. And I also like to point out and remind people, Sarah mentioned on the slide about enforcement, that when the DOL took up 156 of these reports, not a single one of them was what it needed to be, right? So I think that we're still, in the middle of trying to figure out kind of what it looks like for a report to be complete and to be what the DOL is actually looking for. And frankly, just knowing how the DOL has dealt with this type of issue in the past, what I am expecting, frankly, is not necessarily guidance in the way of, let's say, new regulations, as much as we might see the DOL and come out and say or publish exactly how a lot of those reports were deficient. And so it'll be kind of one of those like, hey, don't do this, right? And we want to see more of this. And so if I had to wager, I'd probably say that they're going to come out with something that's going to say that, this is how we found them to be bad, right? I see a question that says, what's the risk of waiting to engage a vendor until the DOL guidance is published? The problem is that you were supposed to be in compliance as of February of 2021. And so if you wait until the DOL comes out with guidance that, frankly, they have been very clear about, the idea that, hey, you should have already had this before we even required this, because if you have NQTLs in your plan, they should already be in parity. They're kind of slow rolling, any guidance on this. And so waiting for that, frankly, you could get a letter from them trying to investigate your plan or requesting this report, or have a participant request this report well before the DOL actually publishes any guidance, right? And so it's one of those things where, it really is a gamble. And so I think if that's kind of the posture that you're going to take, you want to at least make sure that you're doing, again, like this warning signs, going through the warning signs list and at least identifying them, trying to work through the self-compliance tool, and do anything that you can do to show that, okay, I am aware that MHPAEA is a requirement. And although I, have not been able to put my hands on one of these reports, I am working on this issue. Anything you want to say there, Sarah?
Yeah, I'd like to build off of that. So if you're not ready and the DOL goes to the investigation and finds out that the plan is non-compliant and you end up on that public list, right? That's that naming and shaming. I know that the plaintiff's bar is waiting for that list and they are ready to, sue those plans because they will likely have members that were denied claims because of these NQTL practices. So that's the risk there too. You just have a target on your back for litigation.
Yeah. Now, I mean, the good thing, well, I guess not necessarily the good thing is that none of you on the call are alone in that, right? This could potentially happen to any plan out there that has mental health coverage. And like I said, this is not an issue that's going away. So I think we're going to continue to see just movement on this from both the DOL and participants and litigation, as Sarah mentioned.
Yeah, and I do think that the DOL is taking efforts to kind of shift their focus towards TPAs that are designing these plans, because going that way, you can just effectuate compliance and corrective action across many plans at once rather than plan specific. That makes sense.
Correct. And that's actually what they did with financial requirements. If they did find an insurer who, let's say, had one plan where we knew that they had financial requirements that were not in parity, by the end of the process with the DOL, they generally got that insurer to make global correction. So that is what they're looking to do. It's just really hard for employers, until that actually happens.
For sure.
So with that, I mean, I think we have 2 minutes for Amber to give a outro, if you will. Thank you for joining us today. And I'm sorry about the static there. Hopefully we can edit that out somehow.
All right. Well, thank you, Beth and Sarah, for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded, and we will be sharing the recordings in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you, everyone, for joining us, and have a great day.